comfortable standing? Sorry. The ninth accused, Corinne, appeared before me for plea. He pleaded not guilty to several counts, numbering 7. For clarity, in the substantive charge sheet, count 1 to 7 of the 12 charges appearing in the charge sheet. Similarly, and for clarity of record, the co-accused who are not present in court took plea on the 9th of May 2023, and each was released on hold of 100,000 shillings with an alternative of cash bail of 50,000 shillings. They paid the cash bail and are expected in court for pretrial directions on the 20th of June 2023. The reason I bring this is because the learned senior counsel, Mother Karua, asked this court to either adopt similar terms of bond or, in the alternative, grant the 9th accused free bond. The basis of this is equality of the accused in trial process, and secondly, that the accused being a reputable leader with what she terms as substantive support base as a fixed place of abode. Similarly, she stated that the accused voluntarily appeared before this court on 24th May 2023, appeared voluntarily before the DCI Nairobi on the 25th May 2023, and has voluntarily and without summons availed himself in court today. She concluded by stating that the accused is not a flight risk. In a little digression to the application, the senior learned counsel asked the court to note the following. First, that the charges herein are politically motivated with the sole intention of curtailing the accused from mobilizing his political support base, hence infringing on the accused's political and civil right of self-expression, association, and assembly. She complained further that when the accused appeared before the DCI on 25th May 2023, he was, through tricks, whisked away from his lawyers, and it only took the intervention of the DPP for him to be reunited with his lawyers. This to her is a demonstration of mischief by the DCI. Mr. Njiru had this to say. Article 27 of the Constitution provides for equality before the law. He laid this basis on the alleged statement by the Deputy President, which in his view jeopardizes the trial of this case. He alleged that threats were issued to young men and specified, though, that they may face extrajudicial killings. He asked that this court should injunct all bodies and organs from making statements and inferences that may jeopardize the trial hearing or statements that are sub judice. He associated himself with the submissions by the senior counsel that the accused should be released on free bond. The lead prosecutor, Counsel Maina, steered away from direct response to the issues raised by the counsel for the accused. She went legal. She asked that the court should make independent view and not driven by mercy, as alluded to by Counsel Njiru. She submitted that the court in granting bail should be guided by the existing bond and bail policy and the relevant laws. She submitted in objection to the accused admission to free bond. she asked that the court should consider a bond or bail that is consummate to the offense. She had either no objection to the accused admission to bond. This is the determination. The law on accused admission to bond is clearly spelled out in Article 49(1)(h) of the Constitution. I deem it fit to restate, quote, an accused person has a right to be released on bond or bail on reasonable condition pending a charge or trial unless there are compelling reasons not to be released. The constitutional rights to bail as guaranteed under the Constitution is therefore subject, the constitutional right to bail as guaranteed under the Constitution is therefore subject to being granted on reasonable conditions pending trial or unless compelling reasons not to do so, and does not mean that the right is absolute. In the end, the discretion to grant bail and determine the conditions rests with the court. In exercising this discretion, the court must seek to strike a balance between protecting the liberty of the accused person and safeguarding proper administration of justice. This was well explained by Mativo J, as he then was, in Republic vs. Danford Kabage Mwangi 2016 EKLR as follows, quote, granting bail entails the striking of a balance of proportionality, considering the rights to the applicant, who is presumed innocent at this point on one hand, and the public interest on the other hand. The cornerstone of the justice system is that no one will be punished without benefit of due process. Incarceration before trial, when the outcome of the case is yet to be determined, cuts against this principle. The need for bail is to ensure that the accused person will appear for trial and not corrupt the legal process by absconding. Anything more is excessive and positive. End of quote. The conditions for grant of bail, the conditions for grant or refusal of bond and factors for consideration have been broadly identified as follows. These are what the courts must consider. 1, the nature of the charge. 2, the strength of the evidence which support the charge. 3, the gravity of the punishment in the event of conviction. 4, the previous criminal record of the accused, if any. 5, probability that the accused will not surrender himself for trial. 6, the likelihood of the accused interfering with witnesses or suppressing any evidence that could incriminate him. 7, the likelihood of the accused interfering with witnesses or suppressing any evidence that could incriminate him. 8, the likelihood of further charges being brought against the accused. 9, the probability of guilt. 10, detention for protection of the accused. And 11, the necessity to procure medical or social reports pending the final disposal of the case. In the case hearing, the prosecution are not opposed to the accused admission to bond. The requirement, there are two choices. is that it be compatible with the offense the accused is facing. My point of interrogation, owing to the accused status in the society, would be ground 6 and 7 as outlined above, and for clarity are as follows. The likelihood of the accused interfering with witnesses or suppressing any evidence that would incriminate him, and the likelihood of the accused interfering with witnesses or suppressing any evidence that would incriminate him. I, however, want to state that the accused has been out on anticipatory bail granted by Nairobi High Court Miscellaneous E-165 of 2023. Hence, in my view, cannot be a flight risk. I, however, wish to observe that, considering the circumstances of this case, conditions ought to be placed on the accused admission to bond, and I give the following conditions. 1. That the ninth accused is submitted to a bond of 100,000 shillings or an alternative cash bail of 50,000 as the other 4 accused. 2. The accused is restrained from making statements either through press or in public rallies which make any direct reference to this case. 3. That the accused shall, in the pendency of this case, never make any contact with any prosecution witnesses known to him in a manner that is likely to jeopardize the trial of this case. Finally, that any violation of the above condition shall lead to cancellation of the bond terms. Those are the orders of this court.